AfriForum down! Down with this damn down!
It's been 8 years since the trigger was pulled in Mdantsane, and 6 months since the East London Magistrates Court handed a guilty verdict. Julius Malema stands convicted of the unlawful possession of a firearm and reckless endangerment. But today, April 15, 2026, isn't just about the guilt, it's about the price.
And the fact that, my ladies, the fourth part of it is that we are not asking for a no punishment. We are simply asking for a non-custodial punishment. And no one can sensibly say that other forms of punishment do not constitute punishment, which is the zero-sum argument posited by the state. There's only one punishment as far as that concerned, is custodial.
Tembeka Ngcukaitobi strategy is a masterclass in mitigation. He isn't arguing that Julius Malema didn't fire the gun. He's arguing that the context of firing changes the character of the crime.
So this is the problem now with item 2 firearms, 22 live rounds before 20,000 people. So in other words, the correct postulation is one bullet in a stadium of 20,000 people. One. That's the correct postulation. And then ask yourself, in those circumstances, should I send this man to prison? And it's so absurd that they say, don't want to send him to prison, send him to prison for 15 years. It's like a game that they're playing. It's a game to inflame the passions of the public.
Ngcukaitobi argues that in the eyes of political leaders, the rifle was a symbol of resistance, not a weapon of war.
And that they say you should actually send him to prison for is that he has no remorse. But they themselves say in Hewitt vs. X, absence of remorse is not an aggravating factor. State says that in paragraph 17 of the ISO value. It's not an aggravating factor. But my lady, there is a fundamental legal problem with the argument. If an accused says, after conviction, I disagree with the magistrate, I'm going to appeal because the magistrate has wrongly found me guilty. The state says, infer from that he's not remorseful. It's absurd because even under section 25 of the Constitution, he has a right to an appeal. And the right to an appeal is based on a view held by an accused wrongly or what, that the magistrate is wrong. You cannot say, I'm going to punish this accused because he articulated a view that I'm wrong. That is just an abuse of judicial authority.
He said, not a single soul was stretched. Ngcukaitobi told the court that he's using the no victim argument to push for a suspended sentence rather than direct imprisonment. This is where the stakes become existential for the EFF. Under South African law, any citizen sentenced to more than 12 months in prison without the option of a fine is disqualified from serving in parliament for 5 years. Some analysts have said that Ngcukaitobi is playing a high-stake game. He's essentially telling the court that if you send Julius Malema in jail for a year, you ain't just punishing a man, you are decapitating the official opposition. He's calling it disproportionate democratic interference.
Then the next reason why they say Mr. Malema should go to jail is, if you look at their supplementary heads, because he's a public leader in their own way. Now here, I sympathize with the state that we say, well, people that are holding positions of society should take responsibility and they should be good examples. But it's precisely the same reason that Ms. Thompson says you should look at Mr. Malema differently. And your ladyship, I want to remind your ladyship, when we were here during the evidence of Ms. Thompson, your ladyship commented, and they said, what's so special about him? The state says he's special. When we now say today, treat him through the prism of section 9, everyone is equal before the law. So in other words, my lady, what we have is that we've got a state that chops and changes its case depending on what it wants to achieve at a particular point in time. Today, they are trying to expand the realm of penal activity as expansive as possible. And then they say, okay, look at the fact that he's a parliamentarian. But when the witness was here, he said, no, his parliamentary position is irrelevant. He must be treated like everybody else. But the court cannot follow that unprincipled approach. Your ladyship must apply section 9 of the Constitution, which says everyone is equal before the law. We obviously take into account that Mr. Malema must bear responsibility as a leader in society. We don't run away from that. But it's precisely because of that factor that we say, if you actually look at the fact that he has been criminally charged, there's a public trial that he's been undergoing. The fact that since the day of the charge, there is not even an allegation that he has ever attempted anything to do with the possession of the firearm. The fact that even before he was charged with these offenses, there is not an inkling that Mr. Malema had the propensity to possess firearms or to discharge them openly and publicly, reckless as the state tries to argue today. And the fact that the public trial itself has a shaming effect on the public representative. It has a shaming effect on the public representative because already people are saying, oh, well, why should he not lose his seat in parliament? Why should he not lose his seat in the JSC?
To win, Ngcukaitobi had to reach back into South African legal history. He cited the 2014 case of Oscar Pistorius, who discharged a firearm in a crowded restaurant. He said that Pistorius received a suspended sentence for that specific charge. Ngcukaitobi is asking the court that if a man who actually unalived someone later was given mercy for a public discharge, why should a political leader who has no history of violent crime be sent to direct imprisonment?
We then deal with discharge cases, which we start dealing with the paragraph 35. That's what Sabadun, that's what Pistorius, Mdantsane, and another, and the other versus S, paragraph 1, yes, 4 judgments. What the pattern appears to be is that almost invariably, in discharge cases where there is no harm, no direct imprisonment is ever ordered. Pure discharge, no direct imprisonment is ever ordered. All of the cases we found, discharge the firearm in the sky. So this case was actually a paradigmatic one because it's definitely in an enclosed room. So here in the court, places full of people, and then Oscar shoots the firearm, and someone shoots it to the roof, and then they say 3 years fully suspended. Don't go to the So the pattern on discharges when no harm is an issue is non-custodial as a default position. For possession, the pattern is mixed. I said from analysis says that there are cases we find 7 years. But virtually every case we looked at that they have cited always involves this one we looked at themselves or some sort of other offense that is the possession is part and parcel thereof. Not one case involves an instance which is what we describe as a fleeting possession. Somebody comes in, takes his firearm, shoots it inside the car, really rapidly, never found a case like that. So it is not correct for my management to ultimately come to the conclusion that the pattern of sentencing in possession cases reflects custodial sentences of between 7 and 15 years. That's just not part and parcel of the law. So maybe what we have, you really have a wide canvas. The wide canvas that starts from only suspended, missed, suspended plus fine, or fines. Then it stretches all the way to 15 years. That's the true state. And we have shown in this case the unique facts that were pleaded by Mr. Thompson. And then the complaint about Mr. Thompson's bias, etc. But the fact of the matter is there's only one witness. One sentence, one witness. The state would have got better than but giving their own witness. Never did so.
The state remains firm. They want 15 years. They argue that a leader should be held to a higher standard, not a lower one. As April 2026 draws to a close, the magistrate's decision will determine if Malema leads his party into the next election, or if he leads a cell block in East London.
He differs from that Bruce gave a direct imprisonment, quite a substantial one in that Romeo Johnson appeal letter. I want to be upfront that the state seeking a custodial sentence, and if we can get the maximum sentence of 14 years, counsel correctly said that we do not rely on the minimum sentence act.
He also, very important and interesting arguments were raised with regards to the racism of the AfriForum. Julius Malema calls this some kind of a target, that he's being targeted by AfriForum, especially since they could not get their way with the chant of Kill the Boer, the farmer. Now they are using this particular case to try to, in a way, silence him.
I hear you fully.
Yes, thank you, Malik. Then they are also complaining that he has complained of racism. Why is the state complaining that Mr. Malema is complaining of racism when he's a victim of racism? Makes no sense to me at all.
Okay, I'm not going to respond to what I'm listening, please.
No, I'm not asking your leadership to respond. It's a rhetorical question. Is why would the NPA complain that Mr. Malema is saying this prosecution is part of a racist campaign against him? Why would they have an issue with that? And why would your leadership be required to put that in your judgment in sentencing.
Obviously, Julius Malema has retaliated and has called this a silencing of his ideas.
Persecution has always been part of our life because capital want to use us to silence the dejected masses of our people. And we know what is at play, and we are not in any doubt that capital has got a central role in trying to silence that radical voice in South Africa. And they use us to say whoever dares to speak truth to power must be taken to jail. We shall not be silenced under any circumstances. They can do whatever they can do, they will never silence us. They can imprison me, but they will never imprison my ideas. They will never suppress the idea of economic freedom in our lifetime.
Others have profusely rebutted this statement, saying that it is not his ideas, it's the action that he took when he decided to discharge the particular firearm in the presence of people, in as much as there's no one who has been hurt, because we haven't heard any arguments from or anyone who has come to the fore or even testified that they were harmed during these discharge of the firearm in the EFF celebration. Let's speak about Mdantsane, who's the bodyguard of the EFF leader Julius Malema, who was the one who handed the firearm to Julius Malema for him to discharge the firearm, who later on was found not guilty. It was revealed that actually the firearm was returned to him.
But it does show that even on the same show, they did not regard the offense to be serious. Why do you return the instrument of the commission of the offense? How is it delivered of the charge? Why?
Which is very problematic, even though it was argued that the firearm was returned after the judgment. But that's the thing, looking at how important this case is, and the fact that someone might face 15 years of imprisonment, that firearm was not supposed to be returned to a man who might have given that person right now who's facing 15 years. This man today, I don't know if I saw him, but when I was watching the proceedings, I think I saw someone that looks like him. It might not have been him. But after he was found not guilty, he's suing the state for 20 million rands for malicious prosecution.
I do understand that Mr. Snyman is proceeding with legal action against the state. Are you able to share more of that with us?
Yes, I can. So we are still waiting for the NPA and the SAPS to respond to the written demand made for payment for more than 20 million rand. This is obviously as a result of the malicious prosecution against Mr. Snyman. The 30-day period that we gave the NPA and the SAPS to respond has now expired. So we'll be actioning papers that will be shortly sent. And if they fail to respond, then we'll have to apply for judgment by default.
So that is the latest course of action.
The state is wasting money. The state is just doing all of these prosecutions without even doing proper investigation or have thorough arguments. Now they're facing this lawsuit. But more than anything, people are asking, why is the firearm still with this guy? And if this case is that important, why is this the particular case? I don't want to talk more about what is currently going on with this particular case, other than for us to wait for tomorrow, where the sentencing will be handed down. I'm not the one to decide what is going to happen or what is not going to happen. Only the magistrates knows whether it's in the interest of justice to give Julius Malema direct imprisonment or suspended sentence. Because, as Ngcukaitobi said, in this particular cases, even when someone is fired or someone was in possession of a firearm, none of the precedents, when you look at all the precedents, none of the people were directly imprisoned, and for that many years. But we'll see tomorrow as to whether Julius Malema will use as an example to send a strong message or what the judge is going to say. Let us see what is going to happen. Let me hear your thoughts, comment your thoughts, tell me what you think. Otherwise, guys, I'll see you in my next upload. Bye.